Hi, everyone. I'm Ying from Singapore. Singapore is known to be crypto friendly, but after what happened last year with Terra Luna, which is Singapore Incorporated, with FTX, which was invested by Temasek, and Three Arrows Capital, which is a licensed fund manager, the authority was a little bit quieter, right? So I've had a lot of questions from my clients about, oh, Singapore no longer crypto friendly, etc. But I think after going through the slides, we might have hopefully a better idea of where Singapore is, at least in terms of regulations. Okay, so maybe I'll go through what is regulated and what is not in Singapore. What is a digital payment token? This is actually quite important because certain activities related to digital payment tokens are regulated or will be regulated in Singapore. The definition of digital payment token is actually very, very wide, as you can see. Particularly, it could potentially cover things like in-game assets, which are on permissionless network, right? It can potentially cover, it does cover stable coins. It does not cover e-money. So in Singapore, the distinction is made between e-money and stablecoin. Okay, so e-money in Singapore would refer to the digital representation of fiat in your in your wallet, like say Uber, if you have top up your Uber, I'm not sure whether Uber does that, but if you have topped up your any wallets or any services that you have, which can be used in other activities that would generally fall under e-money, the traditional stored value or facility definition, right? And then we have limited purpose digital payment token. And what does that mean? Limited purpose DPT would cover things like, again, let's go back to the in-game asset structure. In-game asset example, it would refer to things like in-game asset that you cannot transfer out, right? So that would be limited purpose DPT, which will not be regulated at all. Oops, sorry. Let me go back to. Okay, and so under Singapore, it's very similar to the MiCA regulations. If under the Securities and Futures Act, any digital asset that takes on securities characteristics, even if it has utility function, would be captured by the traditional Securities and Futures Act. Okay, and under this, the Monetary Authority of Singapore, MAS, is very, very active. It is starting this thing called Project Guardian, which is essentially a project with many experiments with traditional financial institutions. So we are, in fact, our firm is working with UBS and MAS to look at tokenization of VCC, which is the fund structure in Singapore. There are also various other experiments carried out by different financial institutions. But that, I think, is quite set in stone. I think the understanding across different countries are the same. If it's a security, it needs to be regulated as per traditional security. And in fact, in Singapore, since 2018, we have had many platforms that have issued tokenized security. So that's all the STOs, right, commonly known. So that is already fully functional in Singapore. The other thing to look at is the Payment Services Act, because this is the act which came up with the digital payment tokens definition. And this is the act that would capture all non-securities like digital payment tokens activities. Okay, I'm sorry for the mess up in the in the layout. Okay, but in coming up with the Payment Services Act, which is relatively new, in 2018, the MAS takes a tech-neutral approach, and it also takes a tech-informed approach. And that means teasing out certain things that's blockchain related or DLT related, and trying to make sure that, that it's covered by existing regulations. Okay, I will try to go through this carefully, okay? Currently, the Payment Services Act is already in effect. And today I'm only touching on activities related to digital payment tokens. So what is already regulated in Singapore? If you're dealing in DPT. So for example, if you're conducting OTC services, that is already regulated. That means you need to have a license before you can operate. The second activity is essentially a centralized exchange where you have possession of funds. Okay, so these two activities are already regulated in Singapore. There are already license holders. There are a lot more people whose applications are still pending. And to be honest, there's 100 over applications that are still pending, a lot of whom we are helping. But there is a delay in that application process. And I think it's because MAS, when they first came out with the Payment Services Act, the focus was only on AML CFT concerns. It's only in the past year that we have quite a few rounds of consultation that focus was placed on on customer protection, right? So there was a bit of delay because there will, I believe, there will be new regulations coming out. In fact, for centralized exchanges, now it is mandatory for them to ensure that their customers' assets are placed in a trust, right? Which honestly should have been done years ago, but now it's in place. So we look at, so these two activities are currently already regulated. You can only operate in Singapore if you have a license or if you fall within the exemption. And what does the exemption mean? It means you have applied for the license 2-3 years ago and MAS is considering your application, right? So the good thing about this is, as long as you fall under the exemption, you're in the list that MAS has published publicly, you will be able to carry out conversations with the payment rails, etc. Okay? And then we came out with the Payment Services Amendment Act in 2021. It's already passed, but it's not put in effect yet. And this actually covers a lot more activities concerning DPT. Transmission of DPT, custody of DPT or private keys, carrying out instructions where there is possession of DPT or private keys, and the last one, facilitating exchange even when you have no possession. And our understanding and our conversations with the regulator is that this will cover DEXs. Right? I'm not sure how they're going to enforce it, but it will cover DEXs. So if you want to operate a DEX in Singapore and you don't want to do AML, KYC, and all the other stuff, don't do it in Singapore. You're not going to get your license. Okay? So what does this mean for these activities? You can still do them. They're not regulated yet, but they will be. When will it be? Our guess, at least in the industry, earliest end of this year or next year. And because of this timeline, what we have been advising our clients who are carrying out these activities is come incorporate in Singapore, start your business, because when the licensing regime starts, the same thing will happen. You put in your application, in time, you would fall under the exemption list, right? So we don't know how long it would take to process those applications, but it gives you that breather. It gives you that breather, and it gives you the chance to speak with the banks, to get your payment rails, etc. And the newest thing of the press is that we are going to regulate stablecoins, which are now considered digital payment tokens, right? But these are the special MAS-regulated stablecoin, and only for those that are pegged to either the Singapore dollar or G10 currency. Okay, Actually, this regime, it's more of a Singapore branding thing. So I'm sure Yemki will have more to say about this later. I'll leave it to him, but I've looked at the regime. It's, I'm not sure whether commercially it'll be attractive to the issuers. Yeah, but what MAS wishes to do is that if you wish to issue a stable coin and you want to have some sort of legitimacy, you can come to Singapore. We will give you the legitimacy if you fall within our regulations, right? If you're not a MAS regulated stable coins, then it will be considered a normal digital payment token. And if you're conducting those activities which I mentioned just now, you will have to be regulated. Okay, in Singapore, it's very, very clear what will not be regulated. Issuance of digital payment tokens, as long as they are not securities, as long as you will not be deemed to be dealing in digital payment tokens, i.e., you issue on a repeated, okay, this is our firm's position, right? I.e., if you do not issue digital payment tokens on a consistent, systematic, repeated basis, I think you're generally quite safe, right? We have done many, many, many rounds of digital payment tokens issuance, and the only thing that we would encourage clients to think about is to make sure that they adhere to basic AML CFT obligations, which apply to everyone in Singapore. Okay, so it's not, issuance per se is not regulated. The second thing is NFTs. NFTs in Singapore do not fall within the digital payment tokens definition, right? And if the NFT is the true non-fungible tokens, I'm not talking about the fractionalized NFT because I think that might potentially fall within different definitions, right? So we're talking about NFTs as long as they represent non-securities, as long as they represent, well, as long as they don't represent assets which trigger other sort of regulations, right? Generally, issuance, trading do not trigger any regulated activities at all. Okay. Again, though, baseline AML CFT obligations, which in Singapore which is actually quite common internationally. I do not think it's very it is not very onerous, right? So we have advised a lot of NFT platforms on how to balance that commercial intention and to ensure that they fit that obligation. Okay, there are some gray areas. A few years back, crypto derivatives issuance and trading. And by crypto derivatives, I mean derivatives where the underlying asset is crypto. Okay, so it does not refer to crypto where issuance of tokens where the underlying asset is, a stock prices. Okay, so those would fall quite clearly under the securities regime. I'm talking about derivatives or ETFs derivatives where they refer to, say, crypto prices. Okay, that does not fall within the SFA. Okay, so a few years ago, it's made very, very clear that as long as they are not listed and traded in a Singapore approved exchange, they will not fall under the SFA. Okay, the new Payment Services Amendment Act does have a very broad definition, which is if you carry out instructions of your client and you have possession of the crypto or possession of funds or even the private keys, then potentially you need to be regulated. So we take the slightly more conservative position that even if you're doing crypto derivatives and you are taking clients' possession of funds, you may be subject to regulation when the PS Amendment Act comes in to effect. The second thing is the lending of customers DPT. So a lot of the staking regimes, etc., that uses retail customers' funds, that is now quite strictly prohibited. So that's not an activity that would be allowed, right? But then it would also probably mean that institutional clients are fine. Okay, I will skip this because it's not that interesting. And because I've been told that my time is up. And okay, that's it.